June 25th meeting of the Zoning Board of Appeals in accordance with the governor's order suspending certain provisions of the open meeting law relating to the 2020 novel coronavirus outbreak emergency. This public meeting of the Zoning Board of Appeals shall be physically closed to the public in order to avoid group congregation. There are alternative public access measures put in place. The meeting is televised via Falmouth Community Television, and real-time public comment can be addressed to the Zoning Board of Appeals utilizing the Zoom virtual software for remote access. The application allows viewers to view the meeting and send comments or questions to the chair via the chat function. Submitted text will be read into the record at the appropriate points in the meeting. And for the Zoom login instructions, you can access a meeting link at www.falmouthmass.us/ZBA. I'll introduce the board at this time. My name is TJ Hurry. I'm the chair of the board. We have Ken Foreman, who is the vice chairman, Bob Dugan, who is the board's clerk, Ed Van Kuren, who is a full voting member, Scott Zielinski, who is also a full voting member, Mary Berry, who is an associate member, and James Morse, who is an associate member as well. Also with us tonight is Noreen Stockman, who is the zoning administrator, and Ashley DeMello, who is the recording secretary for the night. Also with us tonight is facilitating the IT help is from the Falmouth IT department, Thomas Cox and Adriana Pantano, and FCTV is helping us out with as well. The board's goal is charged with applying the zoning bylaws for the town, and we consider requests for special permits, variances, and appeals as provided in the bylaws which have been approved by town meeting and the Attorney General's Office for the Commonwealth. All decisions are made through the public hearing process. The board's goal is to hear testimony from the applicant and from the public, and also to allow a full and fair discussion of the project prior to rendering a decision. To begin each hearing, the clerk will read the public announcement of the hearing and then present any pertinent information from the file, such as referrals from town departments and summarizing correspondences to the board. The applicant or the applicant's representative will have 15 minutes to make a presentation, and time may be extended by vote of the board. The board will then question the applicant, and the public will be invited to comment as well. Public comments should be directed only at the project itself, and we ask you to please refrain from making any personal or derogatory statements. Such public comment can include an opinion in favor or in opposition, or it might just simply be a question about the nature of the project. All members of the public wishing to speak can utilize the Zoom chat function. And again, that link is provided at www.falmouthmass.us/ZBA. We ask you to include your full name and address for the record, and we will address those public comments when the time comes during the public hearing. The board will then either close or continue the hearing. When the board is satisfied that enough information has been presented by testimony and in the file to make a decision by motion and vote of the board, the hearing would be closed. And the alternative, the board may continue the hearing to a future date and time certain. After the hearing is closed, no more testimony may be taken. And as for board discussion and decision, the board may then further discuss the project among ourselves and make a motion to deny or approve would be made and voted upon. The motion will include a summary of key findings and conditions. An affirmative vote of 4 members, which is a supermajority, is required for approvals of motions on special permits, variances, and appeals. A split vote, such as a 3-2 vote, would be a failure to carry and would result in denial. Under Massachusetts general law, if a special permit is denied, the applicant cannot return to the board for 2 years unless the project is substantially different. So turning to our agenda for the night, we have public comment, we have 3 continuations, 3 new hearings, and items on our open meeting agenda. So first up is public comment. This public comment portion is meant for anyone out there who has any sort of comment or question, something that is not addressing anything on the agenda tonight. So if anyone out there has anything for public comment, go ahead and utilize the webinar chat, post your comment, and it will be addressed if there's anything there. but we'll move on with the agenda. If anything pops up, I'll be sure to mention it. Up first, we have two continuations, 63-19 and 87-19, Cachadori and Ballas, 18 Drive in East Falmouth. But Noreen, I believe the applicant's representative is not available at this point, so it might be best to table and take it up later in the evening.
So, Mr. Chairman, I can make a motion just to take the continuations out of order.
Sure.
Well, excuse me. Sorry, we had a request to do -20 Falmouth Housing Trust, Inc. first, please.
Sure.
Lots 9 and 10 Pam's Way.
All right. Bob, if you want to make any sort of motion.
Yes, a motion to take the continuations out of order, starting with application 003-20, Falmouth Housing Trust, Inc., lots 9 and 10 Pam's Way, East Falmouth.
Second. I'll second.
All right, so the motion's been made by Bob, seconded by Scott. Roll call vote. James?
James Morside.
Ken?
Ken Forman, aye.
Ed? Oh, Ed, I think you were on mute there. Oh, you just muted yourself again, Ed.
Ed Van Kuren, aye.
There we go. Mary?
Mary Berry, aye.
Scott?
Scott Zelinski, aye.
Bob?
Robert Dugan, aye.
And TJ Hurry, aye. So we will be taking application 3-20, Falmouth Housing Trust, lots 9 and 10, Pam's Way East, first, and out of order for the agenda.
And Mr. Chairman, we are in receipt of a letter from Attorney Laura Moynihan dated June 18, 2020, regarding Falmouth Housing Trust, lots 9 and 10 Pam's Way, East Falmouth, Mass, appeal number 003-20. Dear zoning board members, I represent the Falmouth Housing Trust, Inc., FHT. The FHT's agreement for purchase of the subject property with the property owner terminated on June 10th, 2020. Accordingly, the FHT is requesting to withdraw the above referenced application without prejudice. And that's signed Laura M. Moynihan with the CC to Falmouth Housing Trust and Robert H. Ahmed, Esquire.
All right, thank you, Bob. Would anyone like to make a motion to that effect?
I'll move that we accept their Falmouth Housing Trust request to withdraw without prejudice.
Second.
Very good, thank you, Ken. So the motion was made by Ken and seconded. I'll give that to James. The sitting members on this were myself, Ken Forman, Bob, Ed, and Mary. So would someone else like to second?
So I'll second.
All right, so the motion was made by Ken and seconded by Bob. Roll call vote. Ken?
Ken Forman, aye.
Bob?
Robert Dugan, aye.
Ed?
Ed Van Kuren, aye.
Mary?
Mary Berry, aye.
And TJ Hurry, aye. So that motion carries unanimously, and that application is withdrawn without prejudice. All right, circling back to the first two continuations of the evening, we have applications 69-19 and 87-19, Cachadori and Ballas, 18 Tajmoon Drive in East Falmouth. And I believe the applicant's representative is not here yet, and it might be best to table this.
I think they are present here now.
Oh, okay.
I think we just need to elevate them.
Oh, now I see him. And Adriana or Thomas, if you could please elevate Brian Wall. Attorney Wall, good evening.
Good evening, Mr. Chairman and members of the board. Thank you for having me again. Before we get going on the continuations, I think the board is aware that under the new hearing section, there's an application 032-20 Dundulis, which is related to these enforcement matters. And I would respectfully ask that the board consider taking that matter first, because the outcome of that will affect the two continuances.
I see. Okay, so in order for that to happen, I believe we would need a motion.
Okay, I guess I could move that we take hearing 032-20 out of order.
Actually,
Dundulis,
that's the last
18
one.
Is that that's the appropriate one? Yes? No?
No, 003-20 was Falmouth Housing Trust.
032-20. Two.
That's the correct one. They just had similar numbers. All right,
That's
so
Dundulis, 18 Tashmoo Drive.
Yeah.
all right, so motion to take that application out of order. Is anyone going to second that?
Second.
Seconded by Ed. So the motion is made by Ken and seconded by Ed to take application 32-20 Dundulis out of order. We'll do a roll call vote, and James.
Didn't want to jump the gun. James Morside.
Thank you, James.
I-
Ken,
I just
Oh,
have a
sorry.
question. I just have a question for the administrator. I just want to confirm that, Noreen, that taking the 032-20, which is listed under new hearings, is the one we take prior to the continuations of 6319 and 8719.
So the order is at your pleasure.
Right, so we're just honoring the request of Attorney Wall.
right. All right, so the motion is roll call vote to take it out of order. James made a motion, or I'm sorry, he
voted yes.
voted yes. Thank you, Ken. So Ken,
Ken Forman, aye.
Ed,
Ed Van Kuren, aye.
Mary,
Mary Berry I.
Scott,
Scott Zelinski, aye.
Bob,
Robert Dugan, aye.
and TJ Hurry, aye. All right, so Bob, if you could read 32-20.
Excuse me, I have one question. Chairman.
Go ahead, Ed.
Okay, why is this not being done by the selectmen? When you go back and look, the original, back 25 years ago when that harbor was set up, it was even then done by the selectmen, the docks and the floats.
Perhaps we can ask that once the application opens.
Well, who do we ask for that?
So this application is before you. Attorney Hoyt is present and he will be addressing that issue for you.
Okay,
So he should
thank
probably,
you.
yeah, he should probably be elevated at this point.
Sure, if we could elevate Attorney Hoyt, and Bob, if you could please read application 32-20 into the record.
So a list of abutters is on file, application number 32-20, being all persons deemed affected by the Board of Appeals under Section 11 of Chapter 48 of the Mass General Laws. You're hereby notified that Frank and Patricia E. Dundulis of East Falmouth, Mass. have applied to the Zoning Board of Appeals for a special permit pursuant to sections 240-3C of the Code of Falmouth to modify the pre-existing non-conforming floats on subject property known as 18 Tashmoo Drive, East Falmouth, Mass. For referrals, Conservation Department does not see an issue with the floats being shifted as depicted on the plan. Planning Board, no comment. Engineering, no site work, so no comment. Fire Department, no comment. Water, no input to Water Department. If water service or dock, then it would require a beach flow protection and vacuum meter. And assessors, no comment. And that's all that we have.
And before we begin, Noreen, I think for keeping things straight, I know that we had certain members sit on Cachadorian and Ballas, and I should appoint the same members for this hearing as well.
That would be my suggestion, because I think a lot of the facts in the cases overlap and you'd have best consistency that way.
Thank you, Noreen. So for this hearing, and again, it'll be the same as the 63-19, 87-19. Voting members on this would be myself, Ken Foreman, Bob Dugan, and Ed Van Kuren.
And Mary Berry.
And Mary Berry.
And Mary Berry, sorry. All right, so that makes 5. Fantastic. Attorney Hoyt.
Thank you. Good evening, Mr. Chairman and members of the board. For the record, my name is Drew Hoyt. I represent Frank and Patricia Dundulip of 18 Tashmoo Drive in East Falmouth. And I know that many of you are familiar with the basic facts and scenario, but since this is a new hearing, just to briefly summarize the background for the record. So as Mr. Van Kuren indicated, not just a few moments ago, the property, my client's property is bounded on the back by a canal called the Tashmoo Canal that was excavated and dug out in I believe it was the 1970s. Create basically a boating community all along the canal goes out into one of the fingers that comes up from the ocean in East Falmouth, and it's used by the residents to access the ocean for recreational boating. Canal is bounded on all sides by a vertical seawall. All along the canal, owners have installed floats alongside and parallel to the bulkhead or seawall that they use to berth their boats. And that's what was done at 18 Tashmoo Drive by my clients, not by my clients, but by previous owners. As early as 1994, 2 floats had been installed at my client's property. And since that time, there have been at least 2. For a while, there were 3. There have been 2 floats at my client's property since at least 1994. The floats are, there's a Chapter 91 license for 2 floats at the property, and there is a special permit that was issued by the selectmen back in 1994, 1995, that depicts 2 floats on my client's property. But as you know, in the other pending enforcement matters that are going to be discussed later tonight, was some dispute about whether that special permit, in fact, authorized the floats or merely authorized the seawall. So the two property owners at the end of the canal who own the properties that are actually on the sort of butt terminal end of the canal had not installed floats like most of the other owners had. Back in 2015, my clients enlarged their float configuration, and as part of that, they actually took one of their older floats and gave it to Mr. Bayless, the owner of 64 Muskegon. And so since around 2015, there has been a float on Mr. Bayless's property parallel to his bulkhead. Problem is that based on the it's a small canal with floats on both sides, all the pretty close to the end on both sides. When the second owner at the end of the canal, Mr. Ketchadorian, bought the property and decided that he also wanted to put a float parallel to his bulkhead at the end, it got to a point where there just wasn't space to do that. So Mr. Bayless and Mr. Ketchadorian decided to apply for permits to stick a float basically from the center line of their properties, basically running up the center line of the canal for considerable distance, and that would have created problems for my client's ability to access their existing floats. Also would have created problems for an owner on the other side of the canal, Mr. Penticus, to access his float. So a dispute arose between, on the one hand, my clients and Mr. Penticus, and on the other hand, Mr. Bayless and Mr. Ketchadorian. My clients and Mr. Penticus opposed the permit applications for that, we'll call it the perpendicular float that would have gone up the center of the canal. And that Mr. Bayless and Mr. Ketchadorian's efforts to get that float permitted have been tied up in litigation and disputes for a matter of years now, and those disputes have, as well, and conservation. Recently, we were able to reach a resolution of that dispute, at least on the Dundulis and Bayless side of the canal. If I may share my screen, I think it might be easier to look at the screen while I talk. Can you see my screen okay? Can you see that diagram?
It's not up there yet, Attorney.
It's not up yet.
You see it now?
There it is.
Yes.
Okay, never done that before. Okay, so this is my client's property, the Dundulis property, 18 Tajmu Drive. This is Mr. Bayless's property, 64 Muskegon. This is Mr. Ketchadorian's property, and this is Mr. Penticus's property. So the proposal that caused the dispute would have put a float basically starting here and up the canal with boats on either side, right? And so that was a concern to my clients who would have had difficulty getting there, making use of this float, and it was a concern to Mr. Penticus. Part of the difficulty in resolving this is that the situation is not the same on both sides of the canal. On the Dundulis side of the canal, there's a fairly readily obvious answer to resolving the dispute, which was simply for the Dundulises to move their floats. Further along away from the end of the canal, leaving room for Mr. Bayless to come in and stick a float, here, replace the float parallel to his bulkhead and leave him room to get a boat in there. And that solution has been apparent for since the beginning, really, on this side of the canal. Problem is that on the other side of the canal, you can see that the amount of frontage on the Pennington's property is less. There's just less room over there. And so resolving that side was harder. And for reasons that aren't really, I won't go into unless you ask me to, the dispute was we weren't able to separate the two sides and resolve one side without also, without first resolving the other. But the breakthrough, the recent breakthrough that happened a few months ago was that we all agreed, the parties agreed, that we can separate and just resolve the Dundulis and Bayless side, and for Mr. Penticus and Mr. Keshadorian to resolve their sides separately. There are a number of differences between the two sides. Among other things, there aren't currently any permits or licenses for these floats, whereas there is a license, and we believe also, as we've in the enforcement case indicated, we also believe that there were selectmen permits for this. So it's just different scenarios. But the good news is that we have come to a resolution that the parties are all agreeable to, which is what is shown here on this on the plan that we've submitted to the board. We're asking the board to basically recognize, number one, that the floats have been there for, that floats have been at the Dundulis property for well more than 10 years, since at least 1994. There have been at least 2 floats. And to issue a special permit that recognizes that there were 2 floats there and that there are 2 grandfathered floats there, but then to issue a special permit imposing conditions and authorizing Dundulis to relocate their floats in a place that will, in a way that will allow Mr. Bayless to put his float and boat in this area parallel. So we're asking for a special permit that, number one, acknowledges the historical presence of floats, and number 2, makes a Section 6 finding and that relocating the floats in the manner proposed on the plan will be no less detrimental than what's currently there. In fact, we believe that it would be beneficial, obviously, because it would resolve the dispute about the access for Mr. Bayless. So in short, we're asking the board to help us resolve, just help us put in place the resolution that the parties have agreed to. Now, as to the question asked about why here as opposed to the selectmen, the answer is that because these floats have been here for so many years, and because there has been at least a dispute as to whether the special permit issued by the selectmen in 1995 that covers at least there's a special permit that at least covers the bulkhead, and we believe also includes and authorizes 2 floats. However, that the Mr. Bayless and Mr. Kachadorian have disputed that that special permit authorizes the floats, rather than what we're proposing to do is to say, without needing to get to an answer on that question, even if the special permit did authorize the floats, these floats have been in place year round. The special permit describes seasonal floats. So at least to that extent, at least to the extent that the floats have been there year round as opposed to seasonally, the floats have been non-conforming to the permit. So because you have structures that have been in place for well more than 10 years and have at least in that respect been non-conforming, that puts us in a situation where the criteria exists for us to come before the board and ask for a special permit to modify a pre-existing non-conforming structure, as opposed to going back to the selectmen. And I guess if we went back to the selectmen, we would be asking them to clarify and amend their 1995 special permit. But where we have already been before this board, discussing the matter for quite some time, and where there is a specifically applicable procedure in the bylaw for modification of a pre-existing non-conforming use, we thought this was the most expeditious and correct procedure to use. So that's why we're here. And we've in connection with our request for the special permit, we've provided sort of basically a visual history of the site by way of aerial photographs to confirm, as I've indicated, that we've had at least 2 floats for a period of time, 3, at least 2 floats present at this property for well more than 10 years, to show that we qualify for as being grandfathered structures. And really we're just asking the board to help resolve a dispute that has been really going on for too long and regrettably has involved the town and has at times been heated. And I know this board has been dragged into it as well. We thankfully have a resolution, and we're just asking the board to help us put it in place. Once assuming we are successful in getting the special permit we are requesting, what the Dundolisses would then do would be to go to Mass DEP and amend their existing Chapter 91 license, and so that at the end of that process, the floats would be fully permitted and licensed in these locations shown on the plan. Mr. Bayless is preparing to file his local permit applications for a parallel float and which would allow him to berth a boat here. He'll be going to the selectmen and conservation, and then after that he'll be going to Chapter 91. And when those steps are complete, everyone in this corner will have their permits will be fully licensed and permanent in the locations that they exist, which I think will probably make them. They will. That will be a rare. That will be. It's rare. They may or may not be the only floats that will be in that situation when we're all done. But I think it's certainly fair to say that permitting and licensing of floats up and down the canal has been spotty. We're trying to do the right thing and get in a situation where we have fully permitted, licensed floats in the locations and have the sizes shown in a way that gives everybody access to the water in this corner. And this side of it is going to be resolved at the selectmen or other venues. Both parties are. Mr. Pennicus has a pending application at selectmen. Mr. Ketchadourian will be bringing forward application to the selectmen. They'll figure that part out. But we think we have the right resolution over here, and just respectfully requesting that the board grant us the special permit that will allow us to move the floats and let Mr. Bayless get in there and access the water.
Okay, thank you, Attorney Hoyt. Attorney Wall, especially since you asked us to take this application out of order, do you have any other comment at this time?
Very briefly, Mr. Chairman, as Mr. Hoyt said, our clients have had this dispute going on for a number of years now, and I like the way that Mr. Hoyt put it, that time has come to resolve it. And so, as I mentioned the last time that I was before you and asked that this be continued to tonight, they have worked out a very detailed agreement to resolve this corner. And part of that agreement is what Mr. Hoyt described, moving those floats 17 feet away from Mr. Bayless's bulkhead. And part of the agreement is that my clients support this. And so we would ask that the board grant the requested relief.
Thank you, Attorney Wall. We'll turn it to board questions at this time, and I also want to just mention if there's anyone out there, members of the public who do have any questions, comments, concerns regarding this project, type it into the Zoom webinar chat. Please add your full name and address for our records, and we will address it when the time comes if there's anything that pops up. But board questions. Ken, would you like to start us off if you have anything?
Actually, Mr. Chairman, could you just pull down the shared screen? Is that possible?
I don't know if I have the ability. I think Attorney Hoyt might have to do that.
Thank you.
Yeah, I do have a couple questions. Thank you. So just help me out a little. What section of the bylaw are we authorizing this under?
I think they're asking for a request under 243C, right?
It's on the front page of our application. I'm going to pull that up on my screen so I can have it in front of me.
The 43C, okay. And so that's based on the idea that you have a pre-existing non-conforming structure?
Correct.
So I'm just looking at the definition. I mean, I don't want to throw a monkey wrench into this because I think it's good that you've reached some kind of accommodation and we'd like to resolve it. But I can't, if I read what structures are, anything constructed or erected, the use of which requires a fixed location on the ground or attachment to something located on the ground, including but not limited to tennis or similar sports courts, swimming pools, more than 24 inches deep, and so forth and so on. I just can't get myself to think of a float as a structure.
Which part of that definition? Well, let me take them both. The first part, as it certainly it's a constructed object. It's made of materials that are put together in a specific form. That's the definition of construction. And as far as the fixed location, I actually included, just exactly for the purpose of answering that, the second part of the definition. Sorry, if I may share my screen again, it's in the set of exhibits that we most recently submitted. I included a photograph that shows the way in which these floats are fixed in a location by being attached to the ground by way of their galvanized steel pipes, basically, that attach the sorry, pardon me. The floats are fixed in their location by galvanized steel pipes that are driven into the bottom of the canal. That's how they're fixed in place. They're in a fixed location. They're constructed objects in a fixed location. So I guess if there's a particular aspect of the definition that you are,
No, I just think we need to be consistent. We'll need to make a clear finding that these are structured. And, but you're moving them, right, from their prior location?
we will be moving them, right? So they're, the fixed location will change if the board authorizes it to do so.
Mhm.
I think the point is they're what, for them to be useful, they can't just be floating about in the canal. They're fixed in place,
Right, I understand that. I
as
just-
opposed to, say, an automobile, right?
And so we're modifying this prior special permit that was issued by the Board of Select,
You're not modifying that permit. You're
issuing a brand new permit.
right, you're issuing a special permit that
Okay,
basically takes a
But-
pre-existing non-conforming use and allows it to continue, allows it to be modified in the way proposed, and then in addition, whatever other conditions that you deem necessary or appropriate as a condition of that authorization. For instance, in the comments, I think there was some mention of, I forget what the exact piece of technology was, some kind of device that one of the local boards would want to see in place for the float. I don't remember if it was a
okay.
bubble or
So
a base or something.
what other permits are required? You've got the Chapter 91 DEP, which you're
Right.
gonna say is still valid?
Right, when we right, when we're going to modify, we're going to request that be right. We have a 91 license in place, and we're going to ask that be amended so that the location shown on the license plan matches the location that we're showing on our this permit application.
Do you also still need a Board of Selectmen permit of some kind?
No,
Doc or something?
no, because this permit would be in place of that, because this is a non-conforming structure that you're allowing to continue. The non-conformity is the absence of either the absence of a selectman special permit or the variation from its terms, at least presently, in terms of it not having been a seasonal float. So this would be in lieu of the selectman's permit, and in the criteria for the special permit we're asking you to grant, it does direct this board to look to the permitting criteria that would apply if we were in front of the selectmen. So basically, this board is directed to look at what the criteria are for that selectman permit and consider them in context of this application. And in our application narrative, I go through what those criteria are for the selectman permit, and they're just broadly defined. The selectman criteria of a selectman permit are that they look out for the best interests of the neighborhood and the community. There's some reference specifically to shellfish views, just the
Well, you addressed 240, 216, I saw. That's zoning. So then how about Conservation Commission?
when we went for our license, the Conservation Commission, not we, but the previous owner had gone to conservation, had conservation approval. That was a prerequisite for the 91 license. And the conservation has just, in their letter, this board has indicated that they have a problem with the proposed relocation.
Okay. Yeah, I just want to be sure we're not going to create heartburn at the Board of Selectmen if we grant something that should be under their purview. I think Ed may have similar concern. All right, well, those are my questions. Thank you.
Thank you, Ken. Bob, anything?
Yeah, first of all, I know we've seen these different hearings, and they're very, very similar. I just want to make sure on the new one we open tonight that I would suggest that we continue it until we make a decision on the former continuations. And my reasoning is this. There were testimony in both of those continuation issues over all the hearing times that we had. And I think that testimony is in direct conflict with what they're trying to do with the new application. And that's my worry. My worry, if we find just reviewing what is on this application tonight, and we've already been given testimony on a similar application, it's in opposition to what's being presented here, that we're actually creating heartburn, like Ken said, for ourselves. So I don't have any current questions on this application, but I do want to handle the continuances before we do this application because of that testimony. And I stated stuff after the last hearing when they asked for a continuance the second time to come to, a mediation and a meeting. And I understand that they've come to some kind of a solution. But my worry is that the solution they've come up with is going to be in violation of what's been presented to us on the other two applications. So I'm not going to ask any questions here right now, but I will be asking at the end of this that we continue this until we hear the other two continuations that were presented.
All right, thank you, Bob. Ed, anything?
Yeah, I have, my understanding is the Board of Selectmen is the granting authority for all docks. And if we go and do make a special permit or do anything, even though I think that's the right thing to do, somebody's going to come along later and say, why is the zoning board involved in this? Why didn't they go back to the Board of Selectmen, who is the granting authority, and get them to modify it and keep it all in one place? I'm not against what they're trying to do, but I'm afraid somebody's going to, wise in 5 years from now, it'll come back and it'll be haunting all of us. So that's my biggest concern. I think we should stick with the Board of Selectmen on this.
Thank you, Ed. Mary, anything?
I don't have any questions.
Okay, thank you, Mary. And I am not seeing any public comment at this time in the webinar chat.
Can I make one more comment?
Of course you can.
So Attorney Wall, who was the opposing attorney, right, requested that we take this forward. That's the only. So there must have been some reasoning there since they've reached accommodation, right? So I just wonder, seems like one part of the solution's contingent on the other part of the solution being approved. That's why I think they want to do it this way.
Attorney Wall.
I would agree with what Mr. Foreman said. I would suggest to the board that if the board finds a way to grant the relief that's being asked for tonight, it would render the enforcement matters moot. So that's why we asked.
With respect to the factual record, the relevant factual record for this permit request is the record of what has existed at the property in terms of floats. And I know that during the other proceedings where we didn't have in front of us, all of the historical aerial photographs. There was, you know, there was discussion about, you know, uh, what that float configuration had actually been over the years, and the point of giving all those aerial photographs and submitting those into the record was to, um, rather than trying to rely on the recollection of the different property owners, to actually um, take advantage of the fact that we have all these aerial photographs out there on the internet, Google Earth and MassGIS, and let the photographs give the conclusive um, statement about what that history has been. So to the extent that in the other proceeding there may have been, differing recollections about what has been at the property over the years, the photographs submitted in this hearing um, speak for themselves. There's nothing, to the extent someone had a recollection that was, different than what the photographs show, the, those recollections are incorrect, whether those were done to Alyssa's or mine or, any other parties. So I don't think there's a conflict between what's happening here and what's happening in the other proceedings in terms of the relevant factual record. We've provided these aerial photographs that speak for themselves. I don't think anything that was said in those other proceedings would or could sort of undo what the photographs show.
So, Mr. Chairman, then I have a question for Mr. Hoyt. If he does not feel that there's any evidence that came up in a prior hearing that might have been a conflict or in opposition to what's being presented tonight, then why wouldn't we be able to hear those first?
I'm not necessarily saying you wouldn't. The issue in this request is substantially narrower than those that are in play in the other proceeding. For instance, here, really, the only question factually is, the one that's answered by the photographs. The and as far as the board's hesitation in this instance to be the permit granting authority rather than preferring it to be at the selectmen. I mean, I would like to be able to answer that, but I think the reason, if you were to take the other matter first and you were to come to the conclusion that the floats were grandfathered and therefore enforcement was not warranted, the enforcement requested was not warranted, which is the finding that we would be asking you to make. That would, I suppose, if that was what you did, then if you did that and then came back and issued the special permit, then that's either or, I think. But problem is, in the enforcement side, there were just a whole bunch of other related ancillary questions that go into the enforcement decision. This is just a smaller, more discrete piece that, if it is resolved, would, as Attorney Wall indicated, it would moot the enforcement matter, because now these floats would be authorized by your special permit in the location that you specify and with the conditions that you specify. It's just a narrower issue, but one that, if you can issue this special permit, it resolves and moots the other matter. So that's, I don't know if you find that a satisfactory answer, but that's how I would respond to your question. I think, with respect to the selectman being the permit granting authority, I do want to say that your bylaw specifically provides this mechanism where if a structure exists that ought to have had or ought to have fully complied with a special permit issued by the selectman or planning board or whoever, but a structure has been in place that either didn't have that permit or deviated from it in some way. Your bylaw has a provision whereby the zoning board becomes the permit granting authority to basically take that pre-existing non-conforming use and allow it to be in this case relocated with conditions. So what our request is completely consistent with the procedures that your bylaw lays out. And the reason your bylaw lays out that provision is that the Zoning Act has a provision requiring that pre-existing non-conforming uses, number one, are grandfathered, but in order to relocate them or modify them, as we're seeking to do, there's a special permit process by which that happens. Or in the Zoning Act, we would just refer to that as a Section 6 finding process. But in your bylaw, the town has decided that to issue a Section 6 finding under the Zoning Act, that the relevant board is this board. It could have decided otherwise, but your bylaw says that for a Section 6 finding and to modify a pre-existing non-conforming use, this is where we come. So there's no impropriety. There's no stepping on toes of another board. This is just the procedure that your bylaw establishes.
So, Mr. Chairman, because there doesn't seem to be an argument against the continuances in advance, I would like to make a motion that we continue this hearing and any decision on this hearing until we take up the prior continuances and make a decision on both of those, because I think they have direct bearing on this application.
Before you do that, Bob, I'd like to ask just one question to, I guess, the applicant, Attorney Hoyt. So obviously you'd like to see the board rule favorably on this and grant it. But what would happen in the event that we don't? Would you just go to the selectmen?
A lot would depend on what happens in the other hearings tonight. We're certainly and we've tried to look at all the different ways that this might go. See, going back to the selectmen, if we were to go back to the selectmen and if we did that, what we would be doing is we would be going back to try to ask them to amend their or clarify and or amend the 1995 special permit. We would start by asking them to clarify that it did in fact authorize the floats, not merely the bulkhead. That was one of the issues that was in dispute. If we're going to be going back to the selectmen, we'd certainly prefer that they be the ones who answer that question as opposed to this board. So if we went back to the selectmen, we would ask them to clarify the scope of their prior permit and amend it as needed to adjust the location of the floats. If however this board had, before we got to the selectmen, issued an enforcement order making to issue an enforcement order, you would need to, and I don't want to get into the hearings that are the later things on the agenda, but since you asked the question, it's hard to go to the selectmen if the board has taken action on an enforcement request because if the board agrees with if the board were to find that the floats were grandfathered and that moving them is to relocate them as we're proposing is a good thing, then then what this board should do is grant this permit. If the board does not make those determinations, then the board necessarily has to answer other questions that are pending in the enforcement hearings, which are what was the scope of the selectman's permit?
Thank you, Attorney Hoyt.
Okay, so now to make a decision on the enforcement case, we'll have had to answer a question about the selectman's permit, which then would put us in a weird position of trying to go back to the selectmen when this board has already issued an order about the scope of that prior selectman's permit. It would be a very it would make that hard. So I think what happens if the board doesn't grant this special permit, presumably the reason is that it doesn't feel the criteria have been satisfied. And if the board doesn't feel that those criteria have been satisfied, then it's going to take us right into the enforcement case, which is going to, honestly, in my opinion, blow up the settlement and put us back in court. I think it takes the selectmen's pathway, makes that selectman pathway difficult. Now, if the board's preference was for us to go to the selectmen first, as opposed to the procedure that we're requesting here, and if the board were to, in order to do that, which we're willing to do. I mean, I think this is the procedure we're in is, I think, the appropriate one and the preferable one. But if the board wants us to go to the selectmen, what I would ask is that, the board not make that selectman pathway much more difficult by issuing an enforcement decision that says, a bunch of stuff that would make it harder to go back to the selectmen. So, if the board were to either, continue the enforcement proceeding, or I think there would be reason to simply, deny the enforcement request without prejudice based on the reasons the building commissioner denied enforcement in the first place. But then, then we would go back to the selectmen. But if we're, but if the result of tonight is that we're, that the board has issued enforcement orders telling us to, get rid of the floats, then we're just going to go to court because that's what we have to do. So trying to be, again, we've reached our agreement between the parties, and now we're just trying to use the right procedure to get the town to, put permits on the floats where everyone wants them to be. I don't think anyone has any reason to not want the floats to be in the places the parties have agreed are, good locations for them. We're just trying to, get everything properly permitted. We think this is the proper permitting procedure. But if you want to send us back to the selectmen, please don't, think that that's going to happen if we've just been, hit with an enforcement order. It might happen eventually, but the first thing that would happen is we would spend the next, 3 years in court, dealing with the enforcement order. Just seems that would be a strange result for situation where the parties have come up with a way to improve the situation at the end of the dock, give Mr. Bayless the access he needs, and for the town to then, throw a wrench in the works. I think so. I guess what I'm saying is the procedure that we're asking for here, I think, is the one that most cleanly does that. I think trying to go a different route ends up putting a wrench in the works. There's no reason to continue this hearing till after the enforcement, unless it's already been decided that you don't intend to find grandfathering and grant this special permit. Right? If there's no need to continue this hearing, all of the facts needed to make this decision are in front of the board. It seems, so I think I'm asking the board to please just look at these facts that are on the record, and if there's a substantive reason to find that the criteria aren't met, then it's one thing. But your bylaws established this procedure. We've provided all the relevant facts. The other parties are, this is what the private parties want. I don't think anyone on the board has indicated they have any substantive objection to what we're proposing out there. I apologize that it's coming to the board this way. But that's just the situation as it is. We have floats that have been there for a very long time, and unfortunately weren't the permitting isn't clean right now, and it should have been, and unfortunately it's not. But that's what the bylaw and the zoning act section 6 have a specific procedure to address, to deal with pre-existing non-conforming situations like this one. So
Mr. Chairman, that's my issue. We have two continuations that have similar cases. They all have bearing. We're not allowed to discuss testimony in those cases here because this is a new application. So if we were given testimony in something that's related to this, I think we need to be able to review that first. And that's the reasoning I think we need to make a decision on the continuations first. We heard, multiple meetings of testimony from both sides, Mr. Wall and Mr. Hoyt. They had a very differing opinions. I know they're trying to, come to a meeting of minds. But if we've been given information that may not allow this, we need to be able to discuss that. And the only way we can discuss it is to handle the continuations first, see how that is resolved or what the final decision is, and then based on that final decision, come back to this case. So as I said before, I would make a motion to continue this tonight until after we have made a decision on those previous continuations.
Mr. Chairman, if I may, I think that's actually exactly wrong legally. Your obligation in this proceeding is to make your decision on the record in this proceeding, not to make your decision in this proceeding based on the record of a different proceeding. If there are questions that you have relevant to this proceeding, factual questions, maybe you recall something that was said in another proceeding and you want to ask about it, by all means ask. But you can't make a decision in this proceeding based on the record of another proceeding.
So that's not what I'm saying.
I'd like to second the motion,
You have to.
Mr. Chairman. Mr. Chairman, I'd like to second that motion.
All right, thank you, Mary. So Bob, if you could just restate your motion, please.
So I would make a motion to continue this hearing to later this evening and to now take back in order the continuances of 63-19 Cachadori and Bayless, 18 Tashmere Drive, East Falmouth, and 87-19 Cachador and Bayless, 18 Tashmere Drive, East Falmouth.
All right, so that motion was made by Bob and Mary seconded it. We'll do a roll call vote. Bob,
Robert Dugan, aye.
Mary,
Mary Berry I.
Ken,
Foreman, no.
Ed,
Ed Van Kuren, aye.
and TJ Hurry, aye. So we will be moving back to the other two applications. 63-19 and 87-19. All right. And Attorney Wall, you were the representative on these two applications, correct?
Yes, that's correct, Mr. Chair.
Right, and I believe the hearing is still open on these two.
Yes.
We didn't close it at all.
No, that's correct. It was continued for various reasons. And then when the settlement was reached, it was continued to this night for that reason. So I guess since I'm up, what I would like to say is that when I asked for the continuance a couple of times ago, I made a representation to the board that you had heard everything and that I was not going to take much more time of the board. And I'll stand by that. I think the board has heard multiple nights of testimony. I would just simply remind you that the primary contention in enforcement matter is that there is a special permit. I think both parties agree on that. It was issued in 1995. My client's contention is that it was solely for the bulkhead and not for the floats. I put up some evidence on the screen when we could still appear in person that showed you all of the documentation from that permit file. And but for the fact that the floats appear on the plan that was provided to the selectmen the night of the hearing and the night of the vote, all of the other evidence in that case is related solely to the bulkhead. And so the enforcement matters essentially seek you to declare that they require a special permit, that the special permit from 1995 does not include floats, and therefore there are no floats. The special permit does not authorize the floats, and therefore the floats lack a special permit.
Thank you, Attorney Wall. And again, if there's any public comment out there on these two applications, go ahead and type that into the webinar chat and we will make that known if anything pops up. We'll turn it to board questions for these two applications. Ken, do you want to start us off if you have any regarding these two enforcement actions?
I don't have any questions on this one.
All right. Bob?
I don't have any questions, just discussion.
All right. Ed?
None.
And Mary?
I don't have any questions.
All right. And I don't have any questions either.
So
Bob,
this-
like you said, if you wanted to have board discussion.
Yeah, so regarding this application, and again, we heard it over multiple meetings. Mr. Wall did present that the 1995 permit did not show the floats on the permit. There was something that was shown on the plan. I think the testimony over time in this application proved that the floats themselves were never permitted by the Board of Selectmen. As far as any kind of grandfathering, there was testimony that these floats had been swapped out over time. The sizes had changed. And they also were allowed, they also had other people using the floats besides the owner. So I don't think there can be a grandfathering of the floats. The other issue I have with this is I don't think the floats constitute a structure. They're removable. the pipe, there may be pipes that are fixed, but the floats are not. So I would contest that we have a situation where the floats were never permitted. There was never grandfathering, and they don't constitute a structure. And in those cases, I would say currently they're not allowed. Now, if we want to ask that they remand back to the Board of Selectmen, and the Board of Selectmen, have hearings on it like we did with a previous application in the same canal, I think that would probably be the right way to go. But there was a lot of testimony, and I read through everything that both attorneys submitted. It's just that Mr. Wall's argument was a very good argument over time, and I don't think we have a way to get around that they were permitted. Don't think we can say they were grandfathered, and I don't think we can say that they constitute a structure. I honestly don't know why. I know they're doing this because they needed the building commissioner enforcement, but we don't hear floats. And I don't think this is something that actually should have been in front of our board at all. So that's where I stand, but I would stand by those reasonings. Again, not permitted, not grandfathered, not a structure, and asked it be remanded back to the Board of Selectmen.
Thank you, Bob. Anyone else? Ken?
Basically, I agree with Bob on this. I think we are exceeding our charge if we, and this would have gone to the application for the new application. I don't think we have the power to grant that permit. But I think Bob's right on the reasons why this should be remanded back to the selectmen. I mean, it's commendable. They've reached a solution, but let's then have a clean set of permits that are done properly. So, yeah, 10 years from now, we're not back in here arguing.
Ed, anything?
Yeah. No, I agree. I agree with what was just discussed. The Board of Selectmen are the official, the authority. You might as well stick with that.
Mr. Chairman, if I may,
One
at the right,
moment, Attorney Hoyt. I'm just trying to get through board discussion. Mary, anything?
Yeah, I just wanted to say that I reviewed very, very carefully all of the documentation that was provided by both sides. I went to the site. I listened carefully to all of the testimony, dating back, I think, to October. And the special permit, in my mind, just doesn't authorize floats. It authorizes bulkheads. And I would agree with Rob's conclusions for the information provided. I would also say that I have spent an inordinate amount of time researching floats, and I probably have learned more about floats than I probably ever thought I would in my entire life. But those are the conclusions I have come to.
Thank you, Mary. And I echo the sentiment of the board that everyone, mainly what Bob summarized.
Mr. Chairman,
Yes.
having heard that consensus of the board, wanted to make a procedural suggestion or request. Clearly, if we want a permit, we're going to need, we're pretty evident we're not going to get one from this board, which means we need to get one from the selectmen. So we're going to be going back to the selectmen. I would ask that this board not send us back to the selectmen handicapped by this board's interpretation of a selectman's permit. If we're going to be going to the selectmen, I would like to be able to go to the selectmen and have the selectmen decide the scope of their prior permit and whether, how to, whether it's amending that permit or whatever, and that I would request that this board, in order to allow that to happen procedurally, what this board could do, and I'm asking that the board do, is with respect to these enforcement requests, um, you know, the building commissioner's decision denying enforcement was a decision based on a lack of information that had been submitted to the building commissioner. No plan, no, it was based on missing information. It wasn't a substantive finding about any of the underlying matters. This board is intended to be an appeals board, reviewing decisions that the building commissioner gets to make in the first instance. I would request that this board, notwithstanding its opinions about the substance of the matter, deny the enforcement request without prejudice, which would allow the Mr. Bayless and Mr. Cacciadoro, if they chose to go back to the building commissioner and renew their enforcement request, if they felt the need to do. I don't think they will find the need to do, because, again, we have a settlement that we're trying to put in place. If this board were to deny without prejudice the enforcement request on the basis that the building commissioner should have had the first chance to make these decisions based on information that he felt he needed, that would not prejudice the Mr. Bayless and Cacciadoran's ability to, renew an enforcement request. If things fell apart and they felt the need to do that, they could go back to the building commissioner and get a substantive, decision. And in the meantime, a dismissal without prejudice or a denial without prejudice by this board would allow me to go to the selectmen to get the permit that we need. We need a permit. We're not going to get it from this board. The board has not ruled on our special permit application, but it's pretty evident what that decision is going to be. So we need to go to the selectmen. We're going to go to the selectmen. But please don't send us to the selectmen with, having put your finger on the scale substantively by making a ruling about a special permit that we're going to be talking with the selectmen about in a very short time. I don't think you need to do that. I think that a procedure, a denial without prejudice keeps this, it just puts you in a situation where you're not issuing a permit. You're not dealing with floats. You think floats are for the selectmen, and this would allow us to go to the selectmen, but it would just let us do it with a sort of clean slate, open, blank page for the selectmen to write on, as opposed to the deference that I think they would feel they needed to give to this board. If the board had made decisions about their permit, I think there would be, I think the board of selectmen would be, we just would be going in with it. It wouldn't be going in, from a neutral position, which I think, in fairness, we ought to be able to do.
Understood, Attorney Hoyt. Thank you. Attorney Wall, would you agree with that?
No, respectfully, I would not. I think it's important to remember what's at issue in this particular enforcement matter, which is whether or not that special permit includes floats or not. And from hearing the consensus of the board, I think the board agrees that it does not. If the board does not take action on this, then I think what Mr. Hoyt is saying is that he does not want to get sent over to the selectmen with a negative light from this board's decision. But the corollary is also true for my clients. My clients do not want the status quo. My clients object to the Chapter 91 licensed location of the floats, because one of the floats is very close to Mr. Bayless's property and essentially precludes him from having reasonable use. So if the board denies the request for enforcement without prejudice, it goes over to the Board of Selectmen under the guise of everything's okay, and we're just asking for a modification or a clarification. I would also say the following too, that my clients, I heard several members of the board talk about the evidence that you've reviewed. My clients have spent a lot of time and money and resources on getting to this point. I respectfully submit that if Mr. Hoyt decides to go to the Board of Selectmen, it's a blank slate for everybody. It's an application for a brand new permit. And I would inform the board, my clients, as part of the settlement agreement, have agreed to also seek permits for parallel floats adjacent to their bulkheads. They're currently preparing plans and intend to submit with the selectmen as soon as possible. I would also inform the board that Mr. Penticus, after this board determined that he lacked a special permit, has a pending application before the Board of Selectmen that is scheduled for hearing on July 27th. So I would submit that if everybody goes over to the Board of Selectmen with their floats and boats shown on plans, it'll either get worked out by agreement or the Board of Selectmen can make a decision and end this. But I don't want to go back. I don't want to give up the ground that we fought for. I don't want to waive my client's time and expense that they've spent to get to this particular point.
Thank you, Attorney Wall. So as far as these two enforcement actions go, the two continuations, the hearing's still open. If we were to do anything, we would have to close the hearing and then come to a decision.
So I'd make a motion to close 63-19 and 87-19.
Second.
Cachadorian Bayless, 18 Tashmo.
All right, motion to close those two hearings. That was made by Bob and seconded by Ken. Do a roll call vote once again. Ken?
Ken Forman, aye.
Bob?
Robert Dugan, aye.
Ed?
Ed Van Kuren, aye.
Mary?
Mary Berry I.
And TJ Hurry, aye. So application 63-19 and 87-19, both of those hearings are now closed.
So then I
And-
would make a motion to uphold the applicant's appeal for enforcement based on the following findings: that the evidence submitted shows that the floats were never permitted by the Board of Selectmen. The floats cannot be considered grandfathering as they've been moved, swapped out, changed in size, and used by other parties. And the floats also do not constitute a structure. And would suggest that from here on, they take it up to the Board of Selectmen.
All right.
You need a
Anyone else?
second? I'll second it.
All right, I was just gonna ask if anyone else wants to add anything or if you wanted to second it.
I guess we just have to add that we're finding for enforcement, so we would request that the building commissioner enforces.
Okay. And Ken, you seconded it?
Yeah.
All right, so the motion was made by Bob and seconded by Ken. Roll call vote, Ken?
Ken Forman, aye.
Bob?
Robert Dugan, aye.
Ed?
Ed Van Kuren, aye.
Mary?
Mary Berry I.
And TJ Hurry, aye. Okay, Attorney Wall and Attorney Hoyt, thank you for your time.
What's the status of the other application?
Yeah, we need to go back to,
We need to go back to application 32-20.
right.
So I would make a
Dundulas,
motion.
18 Tajmu Drive.
So I'd make a motion to now take up the previous application that we continued, which is application 32-20, Dundulas, 18 Tashmu Drive, East Falmouth.
Second.
I'm sorry, Bob, what was that motion?
That we now take up the previous application that we continued till after this one, which is application 32-20, Dundulas, 18 Tashmu Drive, East Falmouth.
Very good. My apologies, Bob. Thank you. And Ken, you seconded that?
I did.
All right, roll call vote. Ken?
Ken Forman, aye.
Bob?
Robert Dugan, aye.
Ed?
Ed Van Kuren, aye.
Mary?
Mary Berry I.
And TJ Hurry, aye. So now we are back with application 32-20 Dundulis.
I think we could, we need, I think we've heard enough here. I think we could close that. Does anyone object?
I agree. Second.
All right, so motion to close this hearing. That was made by Ken and seconded by Ed. Ken?
Ken Forman, aye.
Bob?
Robert Dugan, aye.
Ed?
Ed Van Kuren, aye.
Mary?
Mary Berry, aye.
And TJ Hurry, aye. So that hearing is now closed.
And I'd be willing to make a motion that we deny this.
Second.
All right, so the motion to deny was made by Ken and seconded by Bob.
The principal finding would be that I agree again with Bob. Docks are not structures; they're not permanently fixed. I did a little search of the bylaw. There's no place where I see the zoning board of appeals empowered to grant permits for docks. It does point out that docks are allowable uses, but doesn't name us as a permit granting authority for docks.
And I'd also add to that by a previous decision on application 63-19 and 87-19, there were findings that these floats were never permitted by the Board of Selectmen, are not grandfathered as they've been moved, swapped out in size and used by other parties, and again, don't constitute a structure as been previously stated by Mr. Foreman.
Okay, anything else? All right, hearing
In
none.
fact, if I could just read one, it's specifically from the bylaw, for example, 240-36. Piers, floats, and docks are permitted when approved by the Conservation Commission and selectmen. So it's explicit in the bylaw that they need to be approved by these other entities to be considered an allowable use.
So we should reference that in the finding.
Yeah, I mean, there's plenty. The 231-6, another place where it references that. Actually, that might not be an appropriate one, but 220, yeah, 240-26 is another spot.
Okay.
Basically,
anything-
wherever it refers to them as a use, it indicates that they need to be approved by the Board of Selectmen and Conservation Commission.
All right, anything else? All right, so that was a motion to deny with the findings that Ken and Bob mentioned. Roll call vote, Ken?
I have one
Oh.
question first, just real quick.
Go ahead, Bob.
No, I just want to make sure that just so we're aware again, so the voting members on this are Chairman TJ Hurry, Ken Foreman, Robert Dugan, Ed Van Kuren, and Mary Barry.
Correct. And thank you, Bob. All right, so the motion to deny this application, motion was made by Ken and seconded by Bob. Roll call vote, Ken?
Ken Forman, aye.
Bob?
Robert Dugan, aye.
Ed?
Ed Van Kuren, aye.
Mary?
Mary Berry, aye.
And TJ Hurry, aye. So that motion passes unanimously.
Thank you all for all the time you put into this. I know it was a long, drawn out one. Thank you.
Thank you.
Have a good night.
Good luck
You
with
too.
the selectmen.
Bob, are there any other motions to take
No,
any
so
other applications
Yeah,
out of order?
Yeah, so Mr. Chairman, I would make a motion on the remaining two new hearings to take Martha's Vineyard Savings Bank out of order, which is application 32-20, and then we would go to 31-28 Hearn.
Very good. So the motion to take those applications out of order was made by Bob. Is there a second?
Second,
Seconded by Ed. Roll call vote. Ken,
Picked on me. Ken Forman, aye.
thank you, Ken. Mary,
Mary Berry, aye.
Ed,
Ed Van Kuren, aye.
Bob,
Robert Dugan, aye.
James,
James Morris, aye.
Scott.
Scott Zelinski, aye.
Very good. All right, so we will take those applications out of order, starting with application, or TJ Hurry, I should say. We will be taking those applications out of order. First with application 33-20, Martha's Vineyard Savings Bank, 78 Main Street in Falmouth. Bob, if you could read it into the record, please.
So application number 33-20, being all persons deemed affected by the Board of Appeals under section 11 of chapter 48 of the Mass General Laws, you are hereby notified that Martha's Vineyard Savings Bank of Edgartown, Mass. has applied to the Zoning Board of Appeals for a modification of special permit 94-88 pursuant to sections 240-28E of the Code of Falmouth to allow for general office use for a bank, convert one of the residential apartments on the second floor to office space, and install a handicap accessible ramp on subject property known as 78 Main Street, Falmouth, Mass. For referrals, Conservation has no comments or concerns about the project. Planning Board, no comment. Engineering, one, this application was reviewed for impacts to public rights of way and public utilities. Both Main Street and Captain Lee Bates roads are public rights of way in this area. No alterations are proposed to the right of way. Any changes within the right of way would require filing a permit with the Engineering Division. Two, any connections or alterations to public utilities would require permission from the appropriate town department. And three, the project must not direct any stormwater runoff to public property, abutters, or public rights of way. Fire Department, no comment. Water Department, there's no impact to the water service to the building. Assessors, the assessors do request an inspection prior to certificate of occupancy. And I don't see anything here at all from the Historical Commission, so when they do the hearing, they'll just have to discuss if there's any issues with historic.
Good. And that does it for the referrals and everything, Bob?
That's it for the referrals.
I
Great,
think we
thank
do
you.
have historic in the file. It might be on the next page, Bob.
Oh, yes, it is. So from the Historical Commission, and this went to Michael Palmer, Town Clerk. It says regarding certificate of appropriateness for 78 Main Street, application number 20-21. Dear Michael, at its meeting at May 5th, 2020, the Falmouth Historical Commission voted to approve the application for a certificate of appropriateness under the Falmouth Historic District bylaw established under Mass General Laws, Chapter 40C, for a handicapped ramp 78 Main Street as submitted by Alan Ports on March 22nd, 2020. At the May 5th, 2020 meeting, the applicant proposed a new handicap ramp onto the east elevation. The proposed work must be done in accordance with the documentation submitted at the time of the application and discussed and revised at the May 5th, 2020 meetings. All approved drawings and plans, including the application with material listings, are on file in the Falmouth Planning Office. Any new work not granted, a certificate of appropriateness or determination of non-applicability, which is to be performed at the above referenced properties within the Falmouth Village Historic District boundaries, for example, changes to architectural details, trim, etc., shall be presented by the applicant to the Historical Commission for review and approval. Adherence to the certificate of appropriateness is enforceable by the building commissioner, and that's signed sincerely, Edward Haddad, Chairman, Falmouth Historical Commission, CC to the applicant and also to Rod Palmer, the building commissioner.
Very good. Thank you, Bob. And once again, if there's anyone out there who has any public comment, questions or concerns regarding this project, go ahead, type it into the webinar chat with your name, full name and address, and we will address it when the time comes. Attorney Terry is for the applicant tonight. Welcome.
Thank you, Mr. Chairman. Before I get started, could I ask that James Anthony, Joanne Gosser, and Kevin Clower be elevated to panelists, please?
Sure. Thomas Reggiana could take care of that, please. All right.
We're
Looks like the
also
gang's all here.
Terrific. We're also expecting Mike McGrath, so if he happens to pop up in the attendees list, if you could elevate him, but I don't see him now. Good evening, Mr. Chairman and members of the board. My name is Matt Terry, and I'm an attorney with the law firm of Ament Clower here in Falmouth. I represent Martha's Vineyard Savings Bank, the tenant of and applicant for 78 Main Street. With me tonight are James Anthony, the president and CEO of Martha's Vineyard Savings Bank, and project architect Joanne Gosser of Synergy MV. 78 Main Street is dual zoned, with the front portion, including the entire main building, in the general residence district, and the rear of the property, which fronts on Catherine Lee Bates Road, in the residential C district. The property consists of approximately 0.8 acre lot with a 2.5-story commercial and residential Victorian building. The building was constructed in approximately 1858, according to the assessor's records, and has been renovated substantially over the years pursuant to applicable permits. The property has 2 existing curb cuts, one from Main Street and the second from Catherine Lee Bates Road. The applicant seeks to amend an existing special permit 94-88, which granted the then and current owner of the property, Dr. Alan Courts, permission to convert the residence at 78 Main Street into professional office space. We are applying tonight under section 240-28E of the Falmouth zoning bylaw to amend the existing post-operative office visit use to general office use for a bank, including the acceptance of customer deposits, and to convert one of the residential apartments on the second floor into office space. 78 Main Street directly abuts a business district with the former Bank of America building to its east, which satisfies the requirement under 240-28E that the subject property be within 500 feet of a business or light industrial district. Our proposed use will continue the existing suitable transition from the directly abutting business district to the residential districts. As shown on the plan submitted to the board, the applicant intends to revitalize this highly visible and historic property, which is currently vacant on the first floor. This renovation will have a positive impact on the visual character of the town green neighborhood. The exterior renovations, including the installation of a handicapped ramp, have already been approved by the Historical Commission. The ramp installation provides a further public benefit as it brings the existing building into compliance with the Americans with Disabilities Act requirements. Finally, the exterior renovations will maintain the character and integrity of the building. The amended use will not have a negative impact on traffic flow or safety. There will be no new curb cuts onto Main Street, and the 2 existing curb cuts allow for the orderly flow of traffic both to and within the site. Further, the amended use will not require more than 13 parking spaces as set out in section 240-108. A new handicapped parking space will be added adjacent to the proposed ramp. This new space, along with the ramp, will increase lot coverage by structures, paving, and parking from 29.1 to 30.2%. The ramp will increase lot coverage by structure from 7.4 to 7.8%. Allowing for an amendment to the existing special permit will result in a continued productive use of the property, desirable internal and external renovations, and occupancy by a highly respected member of the Falmouth community. It will preserve suitable transition from the business district, is in line with the requirements of section 240-28E, and in harmony with the general purpose and intent of the zoning bylaw to allow professional offices, providing they are a suitable buffer between business and residential uses. For all of the stated reasons, we ask the board to grant this amendment to the existing special permit. I'm happy to address any questions that the board may have at this time. Thank you for your consideration.
Thank you, Attorney Terry. And the voting members on this are the regular voting members, if I didn't already mention that. Board questions. Ken, do you want to start us off?
I have no questions. I think it's an excellent project.
Mary?
I have no questions.
Mary? Ed?
No, I have no questions. Be a good use of the building.
Bob?
No, I have no questions. I think it's good use too. Actually, just one question. The plans that we have, are these the same ones that were revised with historical on May 5th?
There were a couple of requests when we submitted our application. So we submitted a revised elevation of the ramp itself because the ramp height wasn't shown. So SK1, the third in the architecturals, now was only revised to show the 42-inch height of the the railing and the balusters on the far left-hand side, the bottom left-hand corner of that plan page. And then with respect to the site plan, it was asked that we add the width of the actual ramp. So we revised to the site plan and resubmitted, and you can see a bubble that says proposed ramp is 5 feet wide.
All right, thank you.
Attorney Terry, the existing apartment that's remaining on the second floor, does that have its own bathrooms and cooking facilities in it?
I'll ask the project architect to address that. I believe that it does.
I believe that it does. I was not able to get in there because it was occupied the day that I was over there, but yes, I'm going to say it's a standalone unit and it will
All
remain
right.
that.
And your lack of access to the apartment, that's why it isn't quite as detailed as the rest of the
Correct.
floor is on the proposed plans.
Correct.
Very good. Just making sure they're not sharing a kitchenette or bathroom facilities with the rest of the proposed office on the second floor.
Yep.
All right, that's all
Just
I
one
have.
quick question. Is the it is on town sewer, isn't it?
It is not on town sewer.
Any follow-up to that, Bob, or?
No, I guess I don't see anything from, they are getting rid of an apartment offices. I just don't know what the regulations are with health. So as long as they are approved by the health department, that the current system, can handle the changes that they're asking for. I guess we would just refer to Board of Health.
I think Scott might have had a question, something there he was indicating you wanted to speak, Scott.
Yeah, you'd probably get less gallons per day with an office than with an apartment. So you'd probably be better off with a residential, the sewer system that's in, the septic that's in it now. Because they're counted by bedrooms, not bathrooms. So I think you'd be better off with it.
Any other follow-up questions from the board?
None here.
Guess I could ask one short set of questions.
Go ahead,
So,
Ken.
just pertaining to parking. Total parking spaces are how many?
13.
And how many employees?
We estimate that at the most, there will be 6 employees on site during business hours.
What is the parking requirement?
The parking requirement is 13 spaces.
Okay. Okay, so I guess you meet it. Thanks.
And I am not seeing any public comment in the webinar chat. So what would be the board's pleasure?
Motion to close?
Yeah, I'll second.
All right. Motion closed made by Scott and seconded by Bob. Roll call vote. Ken?
Ken Forman, aye?
Ed?
Ed Van Kuren, I.
Bob?
Robert Dugan, aye.
Scott?
Scott Zelinski, aye.
And TJ Hurry, aye. So the hearing is closed. How would the board like to proceed?
So I'd be happy to make a motion to approve. My only question is, I'm sure there's a lot more detail that needs to be in this because it's a modification of a special permit. So I don't know if we can maybe ask the administrator to draft a positive motion. We can start some findings and conditions, and that way, if there's anything else that has to be added in, we can do that before vote at next hearing.
All right. I think that's an appropriate motion.
Second?
All right. Bob, would you?
Well, I guess for findings, this is for a modification of the existing special permit 94-88, applying under 240-28E. They're seeking, they will be allowed to have general office use for a bank, which includes customer deposits and the conversion of one of the residential apartments on the second floor space. Property is general residence and residential C. Property does border the business district.
Conforms with parking regulations from the previous permit, right?
Yeah, so he said they have 13. So the previous permit said I don't know why, but it said they had less than 13. So I think we should just make note that currently they have 13, which is required. The addition of a handicap ramp. There'll also be a handicap space. And that would be something that would be allowed anyways under ADA.
Historical.
They have a certificate of appropriateness from the Historical Commission, and it's based on revised plans from May 5th of 20. Those plans filed at the planning office. With the addition of the handicap ramp, there'll be a slight lot change in coverage from 7.4 to 7.8. And lot coverage by structures, parking, and paving with the addition of the ramp from 29.1 to 30.2. It's a reasonable increase. I think we should just note that there was no referral from health, but they are removing a residential apartment, which should have less use on the current system, which is a private septic system. It is not on town sewer. You know, it's in harmony with the district, especially with the business district.
Any other findings?
It's definitely in keeping with the rest of that area, so.
All right. Conditions?
I guess the main would be per plans, and to make sure that the plans that we have are the same plans that have been revised with historical, just so all the documentation matches.
The drawings we have are stamped May 15th.
Yeah, so they can just double check and just, or the administrator can just make sure that our plans are current with the other ones. Adherence to the certificate of appropriateness with Historical Commission.
All right, any other conditions?
I guess I don't think I'm not even sure if this applies, but I know we didn't go over hours of operation. Does anyone have any issues with? I mean, I think it's fine because it's on the business district. But any comments?
Banker's hours.
Yeah, I mean, I think it fits in the area. So
The banker's hours are getting less and less.
yeah,
Yeah, I don't think we need a comment on that since there wasn't any testimony.
I mean, we might want to make a fine, and this is gonna, I don't know if it's strange or not, but we did lose a bank on that end of the street. So it is nice to, have another one there. The closest bank is much farther away for anyone to use.
Yeah, I wish they'd bought that other bank building. Probably a few more bucks.
All right, so if that does it for findings and conditions, that was a motion directing Noreen to draft a positive motion. Motion was made by Bob and seconded by Ken. Roll call vote. Ken?
Ken Forman, aye.
Ed?
Ed Banker and I,
Bob?
Robert Dugan, aye.
Scott?
Scott Zelinski, aye.
And TJ Hurry, aye.
We'll have that ready for July 9th.
All right, thank you, Noreen. And Attorney Terry, thank you to you and your team.
Thank you very much. Greatly appreciated.
How would everyone feel about a quick 5-minute break?
Works for me.
All right, we will take a break
You're the
and we'll be
boss.
right back. And up next, we have application 31-20 Ahern, 27 Fresh River Lane in Falmouth.
So application number 31-20, being all persons deemed affected by the Board of Appeals under section 11 of chapter 40A of the Mass General Laws, you are hereby notified that Francis X. Ahern and Christina M. Ahern of Rentham, Mass. have applied to the Zoning Board of Appeals for a special permit pursuant to sections 240-69E of the Code of Falmouth to raise and reconstruct the existing single-family dwelling, increasing lot coverage by structures on property known as 27 Fresh River Lane, Falmouth, Mass. For referrals from engineering. 1, this application was reviewed for impacts to public rights of way and public utilities. Both Fresh River Lane and Stratford Road are public rights of way in this area. Driveway alterations are proposed to the right of way that would require filing a permit with the engineering division. Additional information will be required to approve a driveway permit. A, the town does not accept stormwater runoff from driveways to the public right of way. There is not enough information to determine if this requirement will be met. B, erosion and sediment controls to protect the town's MS4 system will be required. 2, we request that the board either require the applicant to obtain an approved driveway permit from engineering division prior to closing the hearing, or that the board include the following condition if the special permit is approved. Condition, the applicant shall obtain an approved driveway permit and post any required bond with the engineering division prior to start of construction. The applicant shall complete the work as approved by the engineering division in the driveway permit. 3, where the site slopes down to the public right of way, we request that erosion and sediment controls are included for this project to protect the town's downstream stormwater system. The engineering division will include erosion and sediment control requirements as part of the driveway permit. We defer to the board if plans should be revised prior to their approval or submitted through our engineering permitting process. We recommend the following condition be included in any approval. Construction of this project shall follow the attached soil erosion and sediment control standards document. 4, we recommend following condition be included in any approval. Upon completion of construction, the applicant shall post the address for residents per section 99.1, affixing of legible numbers required and time limit for compliance. 5, there's an existing post and rail fence that is located within the town layout for Fresh River Lane and Stratford Road. Private structures located within any town layout are required to have a license from the selectmen. Is this fence licensed? 6, any connections or alterations to public utilities will require permission from the appropriate town department. 7, the project must not direct any stormwater runoff to public property, abutters, or public rights of way. From the water department, the existing structure has a meter pit. It's located in the grass adjacent to the driveway. The service was installed in 1971. We require that meters be relocated within the structure on raise and rebuilds, and that the existing service line be upgraded to 1-inch PE in accordance with the water department standards. Plans show a partial new service in the existing meter pit under a paved driveway. The pit shall be removed and pit and meter returned to water department. Application for new upgraded service shall be made at the DPW office at 416 Gifford Street. From the building department, from Rod Palmer on May 15th, I reviewed the plans and have no comments at this time. From planning department, no comments. From Amy Lowell with the wastewater, she's the wastewater superintendent. This property is connected to the sewer, so the town's flow neutral bylaw applies. It appears that 3 bedrooms are proposed. There are 2 other rooms on the first floor, an office and another adjacent room, which is unlabeled. Both appear to be less than 70 square feet, so not to be considered bedrooms under Title V. No variance is required under the flow neutral bylaw because the proposal plan does not involve increasing the number of bedrooms beyond 4. From the assessor's department, no comment. Fire department, no comment. And there is a sheet that was submitted that shows lot coverage comparisons for 27 Fresh River Lane. And that's all we have right now.
All right, thank you, Bob. And once again, the voting members on this will be the regular voting members. And if anyone out there has any question, comment, concern about this project, please use your full name and address, type it into the webinar chat, and we will address it when the time comes. Attorney Clower.
Good evening, Mr. Chair, members of the board. Before I begin, first for the record, my name is Kevin Clower, and I'm an attorney with Ahmed Clower Law Firm here in Falmouth. Before I begin, could we elevate, the applicant is actually here, and in case any questions come up that I'm not familiar with, I'd like to have him available, and that is Fran Ahern. Wonderful.
All right.
So this evening, I am representing Francis and Christina Ahern. They are the owners of 27 Fresh River Lane and the applicants in this matter. They are seeking permission to raise and rebuild the existing non-conforming dwelling at the site. 27 Fresh River is located off of Surf Drive, essentially behind Bywater Court. This property is a corner lot fronting on both Fresh River Lane and Stratford Road. The lot is 9,667 square feet. It's located in the residential C zoning district, and it is located entirely in the AE12 flood zone. The existing structure at the site is a 1.5-story, 4-bedroom dwelling with a large deck and a detached shed. The footprint of that structure is 1,957 square feet, and it has an existing ridge height of 21 feet. This structure is non-conforming in a number of ways. The front yard setback is 19.1 feet to Fresh River Lane and 22.4 feet to Stratford Road, and 25 feet would be required in at least one of those instances. The shed is non-conforming to the rear and the side yard setback. The rear yard setback is 2 feet where 10 feet is required, and the side yard setback is 9 feet where 10 feet is required. The existing lot coverage by structure is 20.2%, where the bylaw allows for 20% by right and up to 25% by special permit. The applicants have owned this property for the last 20 years, and they are in the process of making this their full-time home. They've sold their Rentham house, and they're making some upgrades and improvements, but due to the location of this property in the flood zone, and the scope of the work that is being that is necessary, the project necessitates elevation to meet the flood zone standards. So, pursuant to the building code and the FEMA guidelines, the applicants have proposed to raise the structure so that all habitable space and the mechanicals are at least 1 foot above the flood zone elevation. That brings it to elevation 13. They propose to construct a new dwelling with a habitable space just under 8 feet above grade. Rather than waste that space underneath, that has been proposed as a garage and unfinished storage. A portion of the roof will be a roof deck, and the railing of that roof deck is the highest point on this structure, and that's 22 feet 3 inches. That's just about a foot higher than the existing ridge height. It will remain, Ms. Lowell said, 3-bedroom. I thought it was a 4-bedroom. I was counting the office, but either way, it is not an increase in the number of bedrooms, and it is on the sewer. The non-conforming shed will be removed, which will eliminate the side yard and the rear yard nonconformities. The front yard setbacks will be improved both to Fresh River Lane and Stratford Road. Both of those will be over 25 feet, thereby eliminating that nonconformity. The lot coverage by structure does have a slight increase to 21.2%, but with the issuance of a special permit, that nonconformity would be eliminated. In the residential C zoning district, lot coverage by structure of over 20% requires a special permit under 240-69E. The board is asked to consider the size and height of the structure relative to the size and height of structures in the neighborhood, the effects of shadow on adjacent properties, impacts on views and vistas from public ways, and the effect of nitrogen on coastal embayments. The impact of this proposal is limited due to the design and the layout of the proposed dwelling. The height increases a foot, the footprint increases only 90 square feet, which constitutes a 1% increase. There's no impact on the views and vistas from public ways. There's no change to the shadow. The structure remains essentially the same size. There's no effect of nitrogen on coastal embayments. And we did submit the lot comparison worksheet for nearby properties, which show that a number of properties have larger gross building area, and a number have larger footprints. Much of the increase in the gross building area of this structure is necessitated by the elevation of the habitable space. This proposal represents a significant improvement over the existing conditions. It will comply with the flood zone requirements. Again, moving all habitable space and mechanicals out of the flood areas will not create any new dimensional nonconformities. It will eliminate a number of existing nonconformities, including front yard setback, the rear yard setback, the side yard setback, and the lot coverage by structure with the issuance of a special permit. This does also meet the standards of 240-216. This is a significant improvement over what exists. There's no adverse effects that would overbalance the benefits that I've already outlined. For these reasons and these considerations, I would ask that this board grant the special permit, and I'd be happy to address any questions that you might have at this time.
Okay, thank you, Attorney Clower. And once again, if anyone out there has any sort of public comment, question, concern, use the webinar chat, type in your full name and address, and we will address it when the time comes. As for board questions, and everyone's rearranged again since we came back. Scott, any questions? Oh, you're muted, Scott.
Yeah, Attorney Clower, maybe not as much a question as a comment. It's a little frustrating to go over a project this size. You get there on your site visit and there's no stakes up. I got there at 4 o'clock on Monday and all the stakes were in a bundle in a concrete block on the site. And unfortunately, I didn't have enough chance to get back there this week. Has it been staked out?
So I'd be happy to address that. The property was staked, and there was a misunderstanding with the applicant and the engineer. And after the Conservation Commission hearing, about a week ago, the stakes were removed. I went to the site today and saw that same thing. Saw the stakes were there, and the applicant and I spoke. We understand that this is not what the board expects. We understand it's not okay. The property, again, had been staked. It was a simple misunderstanding. We're happy to have it restaked, and we understand that there'll be no decision this evening in all likelihood.
All right. Thank you. Thank you, Mr. Chairman.
Thank you, Scott. James, any questions? Bob?
Just for clarification, Kevin, what was the ridge height again? The proposed versus the current?
The existing ridge height is, bear with me, the existing ridge height is 21 feet. The proposed is 22 feet, 3 inches. And that's
okay,
the height of the railing.
Okay, so to the top of the railing on the roof deck, correct?
Yep.
3 inches. No, that's the only question I have on that time, and thank you for addressing the stakes. I actually went back there today and saw that they were still there. So, if you can inform us once the stakes are put back, then we can take another visit.
Yeah, I spoke with the engineer this afternoon at about 4 o'clock, and he said, I can have somebody run out now. And I said, let's not, there's no point in it. No one's coming between now and the hearing in all likelihood. But we'll see that is staked in the next day or two.
Just one more question. Engineering commented on the fence. Do they have a license from the selectmen, or would they just be relocating that onto the site?
I'd have to discuss that with the applicant. I imagine that they'll have no objection to either relocating it or removing it.
That's all I have.
Thank you, Bob. Ed, any questions?
No questions. Pretty straightforward.
All right, Mary.
No questions.
Thank you, Mary. Ken.
What is the the driveway? How's that going to be paved? Permeable, non-permeable.
Well, let's see. It says existing driveway to be removed, and
It's a significant driveway. That's why I asked.
yeah, given that the lot coverage by structures, paving, and parking remains the same, it must be a non-pavement material.
Okay, well, it'd be nice to know.
Mm-hmm.
Anything else, Ken?
That's it.
Thank you, Ken. And
Mr.
my
Chairman,
question-
just a comment because I missed it in the file. There is an order of conditions from conservation
Thank you,
that's
Bob.
been approved.
I don't have any questions. My concerns were already addressed. Looking in the webinar chat, I don't see any public comment either. And I know, given the concerns of the board members, I know that Bob and Scott brought up the issue of the staking. I suppose we may be looking at a continuation just to get an understanding of the layout of the property.
With that continuation, just for the applicant, where the engineers had commented that they didn't have enough information to determine if the requirement had been met on item number 1. Maybe the engineering could submit that to, their engineer could submit to the engineering department so that we can handle that issue.
Very good.
Also, the driveway material.
All right, anything else?
Mr. Dugan, if I can just specify, just so I can make reference to it when I speak with the engineer, which engineering comment was that? Was that engineering comment number 1? You're muted.
Oh, you're muted, Bob.
Yeah, so engineering comment number 1, and it under A, it just says there isn't enough information to determine if the requirement will be met or not. So whatever they need to determine that.
All right. Noreen, I'll defer to you in terms of when a good date is.
So you are pretty heavily booked for July 9th, including a draft for a decision that you want to look at as well. So I guess I would have to pick July 23rd.
All right. Would anyone like to make that motion?
I just have one question to the administrator, and I don't know if this applies or not, but at town meeting this past Monday, we're informed the next town meeting is scheduled for July 22nd. I don't know if that town meeting would go more than one day or not. So just so the applicant understands, if that town meeting is scheduled and it goes to multiple days, I know I'm a town meeting member and I would be attending. I think Mary is, I think Ken is.
Right,
So we might have to
law-
reschedule.
How heavy is that warrant, Bob? Do you know?
Well, it's really up in the air because this last meeting, we only went through so many articles and then they cut it short before it got too dark, but I don't know how many times they can keep extending it. I guess we just have to keep an eye on what's announced by the manager's office and also the moderator.
Right, so I did check into that for you. As you may be aware, by law, you cannot meet on a night when town meeting is to be held. So I did check in to see if there would be a continuation of town meeting. If it's, and there still seems to be some unknown facts about whether, even though they've scheduled it for July 22nd, if it would actually be held that day or not. They haven't specified where. So at this point in time, given the amount of material that's up in the air, we've made a determination to maintain our zoning board date. You know, if town meeting is continued, we would have to reschedule, but at this point in time, there's not sufficient information within the town to suggest that we could not meet that day.
So then I'd make a motion at this time to continue the hearing to July 23rd.
Second.
All right, motion to continue to July 23rd, made by Bob and seconded by, I think, Ed. We'll do a roll call vote. Bob?
Robert Dugan, aye.
Ed?
Ed Van Kuren, aye.
Ken?
Ken Forman, aye.
Scott?
Scott Zelinski, aye.
And TJ Hurry, aye. So that hearing is to continue to July 23rd.
Thank you very much, guys. We appreciate your time.
Thank you. All right, that does it for the hearings. On to the open meeting items, voting the minutes from May 28th, 2020 and June 11th, 2020. First, the minutes from May 28th. Has everyone had a chance to review them?
Yes.
All right,
Yes,
make any sort of motion?
So motion to accept minutes from May 28th, 2020.
second,
All right, motion to accept the minutes made by Bob and seconded by Ed. Roll call vote. James?
James Morse, aye.
Bob?
Robert Dugan, aye.
Ed?
Ed Van Kuren, aye.
Mary?
Mary Berry I.
Ken?
I was back by then, is that correct?
I think you are.
And Foreman, aye then.
All right, Scott?
Scott Zelinski, aye.
And TJ Hurry, aye. So those minutes are approved. Minutes from June 11th, 2020.
So I did not review June 11th, so I'd like to table the minutes for June 11th, 2020.
All right. We'll table that for the next meeting. The discuss draft decision with possible vote, application 19-20 Mannix Shields, 10 Crown Ave in Falmouth. And the voting members on this were myself, Ken, Bob, Scott, and Ed. So everyone had a chance to review the draft.
Yeah, so Mr. Chairman, just for the public, since it's Zoom, should I read in the findings and the drafted findings and conditions?
Probably a good idea, if you could, please.
All right, so findings, the subject property, 10 Crown Ave, Falmouth, Massachusetts. The premises is located in the single residence B zoning district. The proposal is to reconstruct the existing cottage on the premises. The ridge height of the cottage shall change from 13 feet to 16.4 feet. The existing lot coverage by structures is 35.9%, which will be decreased to 35.5%, where the maximum allowed is up to 25% by special permit. The lot coverage by structures, parking, and paving is currently 62%, which will be decreased to 61.9%, where the maximum allowed is 40%. Finding 1, the cottage was documented as being in existence prior to the previous zoning board of appeals decision in 1998. However, the applicant reported an inability to provide documentation that the cottage predated the May 19th, 1959 date as provided for in the bylaw to establish a second dwelling unit on the premises. The applicant has agreed to remove cooking facilities within the cottage. 2, the single bedroom in the cottage on the premises will comply with the 6-bedroom septic system for which a Title V permit was issued in 2018, where the main house has 4 bedrooms. The applicant has established that there exists space on the premises to provide for a replacement septic system, should that be required. 4, the premises was subject of a previous zoning board of appeals decision in 1998, where the work was proposed on the main house. A modification of that special permit was requested. However, the board determined that this approval would properly be issued a separate special permit. 5, due to the size of the premises and lot coverage by structures, there is limited parking available within the premises. The current parking area encroaches southerly into the town's road layout for Crown Avenue. 6, engineering has required a correction to the address of the cottage. Provision made for capture of stormwater and no stormwater leaving the premises. Engineering has also requested the cobblestones and fencing in the road layout be removed to allow for snow removal. 7, no new nonconformities are created and modest improvements are designed for lot coverage by structures and lot coverage by structures, parking, and paving. 8, the replacement cottage will fit within the character of the neighborhood. In addition to the above findings, the board finds that the proposed reconstruction does include consideration as set forth in section 240-216 of the Code of Falmouth. The zoning board of appeals weighed the effects of the raise and reconstruction of the cottage on the premises, as discussed herein, and found that the beneficial effects for granting the special permit outweigh any negative effects there may be. The board further found that the granting of this special permit will be in harmony with the purpose and intent of the zoning bylaw, and that the change, extension, or alteration shall not be substantially more detrimental to the neighborhood and will not nullify or substantially derogate from the intent of the proposed bylaw. Then we would be voting. These are the following conditions. 1, construction shall be substantially as shown on the plans. SSK 2, parking, I think it should be exhibit, it just needs a typo. For number 10 Crown Avenue, prepared by Holmes and McGrath, Worcester Court, Unit 4A, Falmouth, Mass, dated 5/27/20. The plan of the proposed cottage, which is dated 5/27/20 and signed June 2nd, 2020. Mannix Cottage, prepared by Jill Neubauer Architects. Revised 6/5. I think it should say 2020 is a typo. Sheets A201, A202, EC101, EC201, and EC202. All date stamped received ZBA April 14th, 2020. 2, the 24.3 foot by 17.4 foot cottage shall be 16.4 feet from the east street line, which is Forest Ave, 2.8 feet from the north, and 29.2 feet from the west. The ridge height of the cottage shall be 19.3 feet. The cottage shall be limited to a maximum 4 foot by 4 foot landing facing the east street, which is Forest Avenue. 3, the applicant shall abide by town engineering requirements. Where no stormwater may be directed off premises, dry wells shall be installed to capture new roof runoff as approved by town engineering. 4, the applicant shall eliminate the meter pit and install a water shutoff inside the cottage. 5, the accessory cottage shall be numbered 10A Cottage Avenue. I think that should say Crown Avenue. And proper addressing must be
Yes.
affixed prior to the certificate of occupancy. The former address used was 41 Forest Ave. 6, the applicant shall permit the assessor to view the reconstructed cottage prior to the issuance of the certificate of occupancy. 7, the applicant shall employ best management practices to limit and manage dust control during demolition. 8, cobblestones and fencing sited in the town's right-of-way shall be removed prior to the issuance of a final certificate of occupancy for the cottage. 9, parking is not allowed in the road layout. The applicant shall ensure that the property line is demarcated and all parking remains on premises. 10, the applicant shall coordinate and consult on any construction activities which may impede traffic flow with the police department. Construction materials and equipment shall be maintained on the premises. 11, the cottage shall remain an accessory structure to the main house and is conditioned that there be no cooking facilities within the cottage. 12, the cottage shall be limited to a single bedroom. 13, hours of construction shall be limited to Monday through Saturday between 7 a.m. and 7 p.m. There should be no construction on Sundays or holidays, absent an emergency. 14, statutory appeals periods and thus the issuance of certificates of appeal have been temporarily affected by court standing orders. And there's a website. Applicants, abutters, and interested parties should consult the standing orders to determine their next actions. Any decision by permit holder to proceed is at their own risk, and the permit holder is urged to consult their own legal counsel. 15, under section 17 of chapter 53 of the Acts of 2020, the requirement to record permit decisions with the registry is suspended for so long as the registry is closed or subject to rules and procedures restricting public in-person access. However, such recording will be required upon the full reopening of the registry, and a copy shall be provided to the Zoning Board of Appeals. The Barnstable County Registry of Deeds continues to accept filings by postal mail during this period, and permit holders are requested to file for recording through this method to all extent possible. 16, any deviation, no matter how minor, from plans submitted and approved by this board shall be submitted to the board for approval prior to implementation of said change. The zoning administrator may make a determination as to whether the changes are minor in nature and can be approved administratively, or whether they will require a hearing for an amendment. Changes made prior to an approval may be subject to a full hearing and are at risk the Zoning Board of Appeals may deny the request. And 17, this special permit shall lapse 3 years from the date of which this decision is filed in the town clerk's office if a substantial use of this special permit has not sooner commenced except for good cause as determined by the Zoning Board of Appeals.
All right, thank you for reading all that, Bob.
So that's somewhat modified from what Noreen sent us at 1 o'clock this afternoon. Correct?
Correct. I think it is. When I got here, I got my own copy because I had called in some changes earlier, so I don't know if my changes were in or they were put in here. Or if they were in the prior one.
There's one thing I noticed. So in the at least in the earlier draft, I think that there was a finding that 3 parking spots be on the site.
I think the issue came up that when, and it might have been because of a question that I had, but on the site that's there right now, the width of the driveway is actually located one side all in the town road layout. So I don't know if there is adequate parking for 3 cars.
Okay.
So that might have been the change. So we felt if
I
we
mean,
made
that
a
was,
change.
I thought it was odd that it was in the findings. It seems to me it's more appropriate to be in the condition.
Yeah, so maybe that's why that was changed, and then the conditions just required that any parking on site be on the property itself. And then they demarcate that lot line so people know where the property line actually is.
Right, but it doesn't,
I read in,
so you don't think it's
I
possible?
read
for
it in
them-
the document today. I read in the document today that there was, this afternoon, that there was 3 parking spaces on the property.
Right, that's what it said in the draft that was sent by Noreen earlier. And it said
Yeah.
that under the findings, and I think if it was gonna go anywhere, it should be part of condition 9.
Yeah.
So if we wanted to include that there are 3 parking spaces on the site, they would have to put a parking space somehow in front of the car.
Right, which I thought was kind of how we, when we were looking at the plans last time, kind of how we agreed that it might be done.
I actually would be fine with it. I think you're better off having 3 parking spaces for the size of the property than having 2, but I just know that the way the current layout is without that driveway in front of the cottage, it's impossible to get 3 cars in it.
Right, no, I agree.
So do you
But
want
I mean,
to
I think
add,
you could modify 9 to say parking is not allowed in the road layout. 3 parking spaces shall be designated on the site or something.
so if we
Yeah.
if we do the 3 parking spaces designated at site, then they're going to have to revise the plan to show a parking area in front of the cottage.
I mean, people can
So-
park on grass.
So
They don't
yeah,
have to.
on our plans, they did show an outline showing that they were going to provide 1 parking space in front of the cottage.
So there
So
we go.
is that plan referred to in the plans that are listed?
It should be. They had like shadowed in the car space. And I think that was part of being the fencing that was in the road layout. They were going to be revising that. And they were going to provide for parking for 1 car in front of the cottage.
Yeah, so as long as they do that, we could refer to that there were the 3 spaces.
Yeah, I just think that's kind of important because parking is an issue in that neighborhood.
So would you put in findings that there needs to be?
I
3
wouldn't put it
parking-
in the finding.
Just
I would
condition it?
I would just say under condition 9, parking is not allowed in the road layout. 3 parking spaces shall be designated on the site.
All right, so I would suggest putting parking is not allowed in the road layout. Applicant shall ensure the property line is demarcated and that 3 parking spaces remain on the site.
Three
So we can go-
parking
Sounds good.
spaces are designated on the plan or something like that.
So why don't we put in that 3 parking spaces will be designated on the premises?
Fine.
Very good. Any other modifications to the
I think there was one, wait a sec, on the height. Yeah, I had a question. So under findings, on the findings, it says ridge height of the cottage shall change from 13 to 16.4. But in the conditions, I think there was a different figure. No, I guess that's, I guess it's okay. The conditions show the height and the width. They don't discuss the, I mean, the width and the length. They don't discuss the height. 24-foot cottage shall be 16 feet from the east street line. The ridge. Yeah, no, in condition number 2, it says the ridge height of the cottage shall be 19.3 feet.
Yeah, I think that 19.3 is correct, but I will go back and look at the plans and verify those numbers for you.
Okay, so if we did, then we just change the finding to 19.3 versus 16.4.
All right, anything else? All right, so again, the voting members on this are myself, Ken, Bob, Scott, and Ed. Would anyone like to make a motion?
So I'd make a motion to approve the draft decision discussed tonight with the changes that were discussed.
I'll second it.
Second it.
All right, motion to approve with the changes as discussed. The motion was made by Bob and seconded by Scott. Roll call vote. Bob?
Robert Dugan, aye.
Ed?
Ed Van Kuren, aye.
Scott?
Scott Zelinski, aye.
Ed? I'm sorry, Ken?
Ken Forman, aye.
And TJ Hurry, aye. So that passes unanimously. All right, board discussion, management of abutter participation for the Zoom hearings. Does anyone have anything new? No?
Just a question on, I had a panic attack tonight. I thought, God, maybe they're not doing it by Zoom tonight. What is the forecast for resumption of normal
People.
meeting? Yeah.
Yeah. The forecast is cloudy with a chance of rain. We don't have any timeline provided.
So they're opening up the restaurant interiors, but they haven't made anything for town services at all.
So we have been advised that people that have taken, I guess, leaves from the town hall in order to take care of children, et cetera, the town is, basically recalling all the employees, but we do not have a firm date yet as to when the town will reopen.
Right. Thank you, Noreen, for the update. Anything else regarding the Zoom hearings?
I do want to thank IT for their fabulous assistance, without which we would be lost.
Oh, always.
Absolutely.
Every night, thank you.
Standing O.
Exactly. No, I think these are working, as well as they can. Obviously, that is true. I think the abutter participation suffered. But
All right. Anything for board updates? Scott, congratulations. He was appointed by the selectmen to the full 5-year term.
Thank you.
sympathies?
We all have our cross to bear, right?
I won't say who, but someone was under the impression it was only a 3-year term. It wasn't Scott, but it's actually 5, so. Anything else for board updates? Future agenda items?
Just
All right.
hearings.
Seeing none,
I do have a question for Noreen. When is Wings Pond comprehensive permit is coming up?
July 9th, yes.
Right.
And we will have a consulting engineer on board that will be doing the peer review. So I
Very
think
good.
that will be of great assistance to the board. They'll look into all the matters that need to be addressed so that it's not the outstanding issues we've seen before.
Right. So
And
this
will
is
they
the
be-
first, this
Oh,
is
go
the
ahead.
first application with our new rules in effect with those
Yes.
consultants.
So will they be attending any of the hearings or doing everything remotely or?
Well, so here's the interesting issue that has arisen is that, you know, some of these consultants are not in the immediate area. And that while they're able to do all this work, it can be of great assistance for them to be able to participate via Zoom as opposed to travel time that the applicant would have to pay for. So while we're still on Zoom, obviously they'll be able to participate that way. But I also thought that I would look into whether IT would be able to provide the opportunity for them to participate by Zoom. So we'll see how it works, I guess.
All right, thank you, Noreen. Anything else for updates? Future agenda items? All right.
Nope.
And Noreen, we do have July 2nd scheduled, right?
Yes, we do. We have that reserved for 40 Shore.
All right, so we have our next meeting July 2nd. Meeting adjourned. Thank you, everyone.
Good night,
Thanks, good
everybody.
night.
Thank you. Good night.
Thank you.